This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hi, everyone. Welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed. We are reading through the Menendez Brothers trial, word for word, everything that was on the record. We are reading through it. Today, we are starting with December 5th, 1995, and it looks like there's no actual testimony today. It's just going to be all arguments and they go for a while. So I'm going to try to put this all in one episode so we don't have to stretch it out into two. It's probably going to be a little bit longer just because of that reason. I have a feeling it's going to get spicy. They're going to be talking about different things, about what Erik can testify to or can't testify to. If you recall, Erik is still on the stand. His cross-examination just begun, and there are still some things that the lawyers need to work out about what Erik can and can't testify to. So without further ado, let us just get started. There's probably not going to be any timestamps because it's just going to be one long reading of arguments. But now you know you have the expectation of what it's going to be. So the following is a proceeding held out in open court outside the presence of the jury. The court says, okay, we are in session without the jury. The defendants and counsel are present and will discuss some issues that we can discuss in the absence of the jury, things that have been pending that we haven't had a chance to deal with. There is a motion pending filed by the defense to limit the cross-examination. It was filed on December the 6th, and I've read it. So let's just go through it. What is the people's response? Mr. Khan says, well, it's our position that we should be permitted to examine the defendant in regard to the areas indicated. I think that these are areas in which the defendant should be questioned so we can ascertain in this trial what his position is. I don't think that we can conclude, based in part on his former testimony alone, that his answers are necessarily going to be different. And the cases cited by counsel, it seems to me, stand for the proposition that inquiry into such areas should not be made where the prosecution would be precluded from calling the person as a witness to rebut the testimony given at trial. But I don't think that that is the case with Dr. Oziel, although it was our position in our case in chief that we did not intend to call him as part of our case in chief. I believe that we should be permitted to examine the defendant in regard to these areas so that we can make a determination as to whether or not we intend to call him in our rebuttal case. And depending upon the nature of his testimony, we may decide that that's an appropriate thing to do. Cases cited by counsel seem to stand for the proposition that where there's no witness available and there's no way the prosecution can rebut such testimony, then the prosecution cannot in good faith ask the questions. But that is not the case here. And as far as the court says, well, let's stick to that one then. Are you going to go on to one of the other objections to some other type of evidence? Mr. Khan says, no, just related to that is the related issue of what we'll do. We'll just stick to that for the moment. The court says, okay. What is the defense response? Ms. Abramson says, well, the response is twofold. Number one, apparently, the people are not saying that they do intend to call Dr. Oziel in rebuttal. They do not have a right to sandbag a confession to begin with. They could have called Dr. Oziel to bring out these matters that Erik Menendez denied ever saying to Dr. Oziel in the first trial and chose not to do so. She's absolutely right. They could have called Dr. Oziel in the first place, but they didn't because he's a bad witness, because he knows that they would call Judalon Smith and discredit him. What they apparently want to do is confront Erik Menendez with statements that they know he denies making and never calls Dr. Oziel. Just get the information in front of the jury. They already know what matters. What matters is he denied and would deny again. They have no reason to believe he wouldn't deny them again. So their statement that they have not yet made a decision to call Dr. Oziel is a thinly veiled, I think, suggestion that they have no intention whatsoever of calling him. And since they're not going to call him and should have called him if they wanted this confessional material in their case in chief, they should not be permitted to bring up matters that only Dr. Oziel would testify to that Erik Menendez has and does deny. And I'll make an offer of proof he would again deny the same things he denied with respect to statements that Dr. Oziel claimed he made in this trial. as in the first trial, and they simply shouldn't be allowed to shield the jury or shield their case from the examination of Dr. Oziel's highly questionable credibility by simply using his information and confronting our client with these false confessional materials in the way that they propose. She's absolutely right. They are trying to sandbag her and avoid calling Oziel in the process. It's very obvious what their trial tactics were. Oziel was a very bad witness for them. They don't want him before the jury. And so they think that they can use his material in this backhand way. And I think the law is otherwise. They cannot. The court says, as far as the issue of so-called sandbagging, the people did not introduce during their case in chief the October 31st or November 2nd conversations. They only introduced a tape recording of a conversation between Oziel and the defendant, the date of which was not precisely established by the prosecution, and one of the things the defense objected to in regards to that was that the people wouldn't be able to establish it. But the defense cooperated and established that date, December 11th, in this case, but went further than confronting the December 11th tape and introduced evidence of conversations that occurred between Oziel and the defendants on October the 31st and November the 2nd. To say now that the people can't question the defendant about those dates because it would be sandbagging would, Ms. Abramson says, that's not what we're saying. The court says, be contrary to common sense. They certainly can, and to say that they are confined only to what the defendant testifies on direct examination and can't go beyond it would deny the people of the right to cross-examine the defendant. To say he could, the defendant can say these things and the people can't challenge it. They're just stuck with what he says would deny the people the right of cross-examination. Ms. Abramson says, we're not saying that, Your Honor. The court says, well, you argue sandbagging, and clearly it wouldn't be sandbagging. That's my best response to your first argument. Ms. Abramson says, well, he did not like that sandbagging comment. With respect to the things that Erik Menendez denied or that he hasn't touched upon at all in his testimony, knowing that he denied them, knowing he will deny them, and having no intention of calling the witness or introducing those matters in this case in chief, I think that is sandbagging. Court says, no, that's not sandbagging. That's just your argument that such questions wouldn't be asked in good faith. Ms. Abramson says, all right. That's the second argument. The court says that they wouldn't have a good faith intent to prove up by direct evidence basis of their questions asked on cross-examination. Other than the people's position that the defendant might change his testimony from the first trial, Mr. Khan, going beyond that, is Dr. Oziel a witness who is available to testify? Mr. Khan says, yes, it's my understanding that he is available, and we, in fact, spoke to his attorney not too long ago, who inquired as to whether we were, in fact, going to use him, and we said that's still up in the air. We haven't ruled it out one way or the other either in this phase of the trial or the penalty phase of the trial, so he is someone who is available to testify. The court says, all right. What I would indicate is this. If questions are going to be asked of the witness, the defendant, based upon statements or testimony of Oziel, which was denied by the defendant in the first trial, that he denied making those statements, the people must be in a position of indicating that they are, although not committing to calling Oziel, in a position to call him. Well, what the hell is the difference? They could just lie and say, yeah, we could call him, but then have no intention of calling him. To prove up the basis of these things, I don't think there's any law that requires the people to make any contractual obligations in regard to that, but they have to have a good faith belief that they could prove up the basis of the questions that are asked. And that's really the only, Ms. Abramson says, I think it goes beyond that. Court says rule. The rule is not one that they have to prove up the basis of everything that's asked, but they can prove it up. It's not a situation where these are things that they could never prove or for some evidentiary rule or legal rule or exclusion are prevented from proving up. Ms. Abramson says, we disagree, Your Honor. We believe that if they don't then call Oziel to prove these things up, that all of that testimony at the very least should be stricken, but worse than that, that the harm's already done. What the court is saying, yeah, they could subpoena him, but I guarantee you they never will, and yet they can proceed now and ask these questions that they think can never prove up, or that they can never prove up, and simply get the Oziel allegations in front of the jury with no sanction for when they don't prove it up, which they won't. So, I mean, there has to be a sanction attached to it because that's how the court can measure their good faith. If our client denies, just as he did the first time, and they don't call the witness, it shows what a sham the whole notion of having a good faith intention of proving it up is. Mr. Gessler for Lyle says, I'd like to be heard since he's a witness for the defense. People versus Lucino itself and the holding of Lucino goes beyond just whether there's a belief on the part of the prosecution that facts could be proved. The next sentence is, and a purpose to prove them if their existence should be denied. So they have to prove them, they have to offer them up to prove their existence if the defense is denying it. That's what this the precedent law says. Now, the purpose to prove them is very important here, as Ms. Abramson said. Otherwise, asking the questions and saying, oh, well, tactically, we decided not to prove it up because there were only 20 answers of no. That's exactly a violation of Lucino case itself because they don't have the purpose to prove them in their existence should be denied. And we have shown that the existence, again, was denied before and certainly will be denied again, most particularly the Billionaire Boys Club, which is the most blatant example. Ms. Abramson says, I think that's another issue. I think that's an 1101 type issue completely separate and apart from this. The court says, let's focus on, Mr. Gessler says, it might be, but I'm not willing to separate it from this argument. I think it's also a very bad Lucino violation and series of violations. Should those questions be asked again in any similar way to what they asked the last time? The Wagner case, which is the Supreme Court case, also shows exactly what we're talking about here, that the prosecutor there just wanted to be, or the prosecutor there just wanted to make the jury believe that the facts existed by inference and by insinuations and suggestions and not by putting on proof of the facts which were denied. And I think this not only is state law, but rises to due process if a case is tried in that way. That it's a violation of federal due process also for the district attorney to insinuate things when they do not have a clear purpose to be carried out to then bring in the witness and prove the opposite. Ms. Abramson says, just another note on the Billionaire Boys Club matter, Your Honor. I don't believe even Dr. Oziel can prove up what that means. The court says no, he just testified to the initials BBC. Exactly, says Ms. Abramson. The court says, and didn't know the significance of it. Exactly, says Ms. Abramson. The court says, that's a separate issue. What is your response, Mr. Khan? Mr. Khan says, well, I think perhaps this depends on how the question is asked. It's one thing to suggest, isn't it true that you told Dr. Oziel the following? I think it's different to simply ask the witness, did you tell Oziel, and inquire into the subject matter of the particular issue. I think while perhaps the former might be subject to greater criticism, I don't see that the same problem exists when you simply ask the defendant whether, in fact, he told something to another person. But it still is like an inference to the jury, like, oh, maybe he did. He probably did say that. They must have evidence of him saying that, or else why would the prosecutor ask that question? That's what the jury is going to think. So it's still an inference to the fact that they have it, if they even have it. The court says, what I'm going to do before the people get into such inquiry regarding questions on what the defendant might have said to Oziel or what Oziel says he said to him is require that the prosecution show that Oziel is under subpoena, not just that you've spoken to his lawyer and that he is readily available to testify. And I will review again the Lucino case. I certainly believe there is great latitude in the scope of cross-examination of a defendant who testifies, and the court does not intend to restrict that scope. By the same token, there are constitutional limitations, and before we get off of the inquiry, I want to first establish that Oziel is subpoenaed and ready as a witness to testify in rebuttal, and then I'll hear further from the parties, and I'll review the Lucino case, which is a case from the Court of Appeal, although the defense cites the Wagner case as well. And I assume there is no case on point on this subject directly on point. Mr. Gessler says, I think Lucino is directly on point, even though it was the star witness and not the defendant himself. It was obviously the person the prosecutors were after. I think the holding of that, I think the Cal Reporter book, because it's what we have out there. The Cal Reporter, it's 14 Cal R PTR 372 is the holding, which I read to the court. Although the whole case discusses the problem here of the prosecutorial misconduct in trying some witness by insinuation. In Wagner, it was the defendant who was on the stand and being asked the questions as though they were true and really lost his right to a fair trial because there was no proof of the court says, was that proof available? Mr. Gessler says, as far as I know, it was if it had been true, Your Honor. I mean, the court says, that's what I'm saying there. There are cases that stand for the proposition that the prosecutor can't ask a witness, isn't it true that such and such happened, and the prosecution is not in a position to ever prove that such and such ever happened. We're in a position here where apparently they have a witness under subpoena who could testify to all the things that are then asked of your client. So I'm saying, is there a case specifically on point that stands for this position that you're now talking about? Mr. Gessler says, well, I think the closest we have is Wagner. It doesn't show that they were precluded from proving this. They were putting these statements on, as I recall. It was some things in Alaska. Yes, at page 616 in Wagner, they're talking about the questions about, quote, isn't it true, Mr. Wagner, then in Alaska, you were not only in the business of putting up fences, but in the business of furnishing cocaine for sale, and in fact, that you have sold heroin. And this video is getting so shadow banned. As far as I know, they must have been able to prove those up to even get past the first hurdle of good faith, which was even before Lucino, that you must believe the fact existed. The court says, okay, well, I'll review those cases, and if the people have any cases on that subject, I'll want to see them as well. Mr. Gessler says the hurdle I still don't understand, and I understand the court is looking as to whether there's a distinction here and the ability to prove, the court says yes, versus simply not the use of it. The court says, so they have it and they're not using it versus it never existed. That's the distinction they're trying to make. The court says if they have the absolute ability to prove up the source of every question they ask, and then they question a witness and they just elect not to put on the source witness to prove up the facts. Mr. Gessler says, how does that make a difference in the eyes of the jury or the propriety of the questions if they decide not to bring in the person? The court says because it's a good faith issue, as to the good faith is the test of whether you could prove it up. Mr. Gessler says it was before Lucino, but Lucino says with the intention to prove it up, that's what they have, the intention to prove it up. The court says, how could it make that determination? If they have a witness under subpoena, how could it say they don't have the intention to prove it up? They make a trial tactical decision one way or another after the witness has finished his examination. Mr. Gessler says, you mean they make a trial tactical decision after all the after all the insinuation with all of the questions that were answered no, making the jury feel that somewhere out of there's somebody to prove it up, and then they say, we got the mission accomplished. Now we're not going to call the witness who is out of state. The court says, I understand that argument, not disputing that perhaps that's the law, but is there a case that says that? Mr. Gessler says, I think Lucino says that, Your Honor, and I think Wagner says that. Now there's no case with a fact situation that's identical to this where there's a defendant who testified. The court says it's not that unusual if you have a situation where the witness is in the hallway and you ask the whole series of questions of the defendant based upon what the witness would testify about. The witness in the hallway would testify about, and you get a lot of denials from the defendant, and Then you never call the witness in the hallway. It seems to me that that's not such an unusual factual context that you would visualize that happening in many trials. So the question is, are these cases dealing with that subject? Not a situation where the issue is, could the prosecution ever have really proved it or not? Ms. Abramson says, I think about when you're talking about a defendant's confession that the people were in a position to prove in their case in chief, and then they chose to do it in this backdoor way. I think the court has to see through the ruse. I mean, it's one thing to say there's a witness in the hallway who once brought heroin. Ms. Abramson says, well, it's another issue then it's another thing. When the witness is in the hallway, when we have a tape that the witness participated in, when the people elected not to call him because he has credibility problems, and we know why. And then to be able to slime in this incredible witness statements without ever having to test his credibility, I think it's completely different situation when it's a defendant confession under this set of circumstances where this witness has already testified once before and the people have elected not to call him because he's not believable. So, how can it ever be good faith to ask a witness or defendant about confessional material to Dr. Oziel when they have already made a judgment that Dr. Oziel's credibility is so compromised that they wouldn't call their chief confession witness in their case in chief? If you recall, Dr. Oziel was basically their star witness, the state's star witness, to say these boys are guilty because they confessed. They didn't even call him this time. I mean, I think you do have to look at what's going on subliminally. And at least, Your Honor, indicate that if the court's going to allow them to ask the questions and then they don't call Oziel, there has to be a sanction. Mr. Gessler says, and I think, Your Honor, also that the theme that runs through Lucino and Wagner is that special credibility that prosecutors carry with the jurors. That a prosecutor, a defense counsel, might do anything in their eyes, and we got a lot of that in the questionnaires. But a prosecutor wouldn't do that. A prosecutor would only ask a question if he could prove it up, and then some terrible calamity out there has prevented him from doing it. But they know that this Mr. Khan and Ms. Nahara, being such nice people and members of the state, representatives of the county prosecutors, would never ask a question like that if they don't believe it was true. And now it was true. And no, it was true. They don't even have to wink at the jury or order, can you stop bumping the mic, please? Let's pause for a minute here. All right. He's fixated now on some bones. So hopefully that keeps him occupied for a little while. He just woke up. So it's being feisty. She continues on. They don't even have to wink at the jury in order to get that across. It's inherent in the role that they play in the courtroom in the eyes of the jury. This is such a great point. Such a great point. In most cases, jurors think defense attorneys are liars. They'll get away, they'll do anything to get their client off. And the prosecutors are saints, and they would never make a mistake or lie or cheat in any way. That's pretty much how a lot of people think about the state. It's wrong, absolutely wrong, knowing what we know now with all these wrongful convictions, but that's what a lot of people believe, or at least, especially at this time in the 1990s. That's basically what people believed was you walk into a court of law, usually the person's already guilty and you don't like the defense attorneys and you like the prosecution. This is what it is. People go in there with a bias. So that really needs to end. Anyways, and that's why both these cases say that this type activity, this type innuendo, is not the way to try a case, that it's a violation, in my view, of due process to allow it to happen. The court says, okay. Also, how do we attack Oziel's credibility when you've put in this evidence by innuendo and question and they've never been forced to call him? Exactly. Great point. How can you refute the question when the question isn't being authenticated by the witness? How can you refute it? You have to remind the jury the questions are not evidence, but you still think it is. You still think if a prosecutor's going to ask that question, they have a reason to, right? I mean, that really was the bias back then. The court says, okay, so your proposal is, first of all, that it not be permitted? Exactly, says Ms. Abramson. The court says, but if it is permitted and then the people don't bring Oziel in, that the questions and answers be stricken. Ms. Abramson says, beyond that the jury be told that those things never, in fact, were said. In other words, undermine, really reverse the damage to say that he never did say those things. Mr. Gessler says, my position goes farther than that. My position is I'd be asking for a mistrial. That's the remedy of Lucino, and that's what I'd be asking on behalf of Lyle Menendez. Court says, okay, all right. Those are the positions of the defense. I've heard the prosecutor's response. I haven't seen any case law cited by the prosecution on the subject whatsoever, although the prosecution has filed briefs on all sorts of other issues. So before this questioning is permitted, the prosecution is, number one, to have Oziel under subpoena, and number two, to provide the court with any case law on this subject, and three, to request a hearing and have the court make a final ruling before the questions may be asked regarding the materials that are contained in the defendant's motion on pages 5, 6, and 7, and up to line 14, which the defense asserts were all denied by the defendant in his testimony, although testified to by Oziel. And the pages here in your brief, these are references to the defendant's denials. Is that it? Mr. Gessler says, that's correct, Your Honor. I went through and, to the best of my ability, gave the page and line for the denial. In some instances, it goes 3 or 4 pages, but it's clear in the 3 or 4 pages with the objections and colloquy that it is a denial. Court says, okay. Mr. Khan says, the court is not ruling, although that the people cannot examine the witness concerning statements he made to Dr. Oziel, which he conceded that he made to Dr. Oziel. I take it as well as we don't agree that in regard to each and every one of these items that the defense has accurately recorded the defendant's position concerning these items. I know at least in one or more areas the defendant said, well, I didn't say that, but I said something similar to that. So it would seem to me that we should be able to question the defendant regarding such statements and have him clarify for the jury. Although he didn't say those precise words, what he did say concerning that issue. The court says, well, obviously, I haven't referred back to the transcript of the testimony and compared to the brief filed by the defense to the transcript. If you have a dispute about it, certainly you can bring it to me or to my attention and we can litigate it. Also, clearly, after those things that the defendant did not deny are open for questioning and examination. Those things that the defendant did not deny are open for questioning. Can you stop with the mic? Don't eat the mic. You have so many toys. Puppies. Mr. Gessler says, I did see some things, sort of what Mr. Khan said, where he said something similar to that. I don't believe I included those things in the brief, but if there are some that Mr. Khan takes issue and can show some pages and lines, I would appreciate him giving me notice of that also, so that I can look at them and compare them to what I gave to the court. Mr. Khan says, well, again, I don't think that it should be the prosecution's obligation to advise the defense of every prior area of testimony of the defendant that we intend to inquire into when, in fact, the defendant, by his own concession in that testimony, says, yes, I did say something like that. I think if the defendant in his prior testimony said, yes, I did say something concerning that to Dr. Oziel, then we should be able to question him about that and say, well, precisely what did you say to Dr. Oziel concerning that issue? Mr. Gessler says, I think, Your Honor, since I have cited to the best of my ability chapter and verse to the court and to opposing counsel, that it's only courtesy that if he takes issue and has some other place in the transcript that he believes puts a different coloration on it, that it be given notice as to where he is relying on, as I have given him notice of what I'm relying on. The court says, well, the issue becomes one of not notice to counsel, but notice to the witness and impairment of the right of cross examination by not being able to confront the witness on the witness stand, but giving advance notice for the witness to prepare a response. Mr. Gessler says, I don't care about other issues in there, but if he is saying that I am wrong on one of the issues I have here, I think that he should show me something that Ms. Abramson says, show the court, is different. The court says, I think perhaps if there is anything here that is enumerated by Mr. Gessler that you feel the defendant has acknowledged in so many words, having said to Oziel, and you're disputing Mr. Gessler's analysis, then before the question is asked, you should provide it to the court, not to opposing counsel at this point. So then the court would review it without forcing the cross-examiner to tip his hand prematurely to a witness. Mr. Gessler says, that's fair, Your Honor. And then again, he still will have to, I take it, license and verse if he's to cross-examine on it. The court says, well, once I look at it, if I rule it's proper, then the questions can be asked in the same way as any other question. If he's quoting from a portion of the transcript, then he'll refer to it. Mr. Gessler says, all right. Ms. Towery says, so that would be an ex parte submission? The court says, yes. Just preserve the right of cross-examination here and not unduly curtail it if there is something that they can ask that covers the same area that Mr. Gessler enumerates here. But again, going back to the overriding issue of whether these questions can be asked, assuming the defendant has made denials in his early testimony, then none of those questions will be asked till there's a hearing. And I expect if the prosecution has any case law that deals with this subject, that you will provide it to me by Monday morning. Mr. Khan says yes. The court says, all right, then let's move on to some other facets of the defense's objection. Ms. Abramson says, can we deal with the Billionaire Boys Club thing right off the bat? Court says, well, that's only referred to in questions that are subject to Oziel. It doesn't have any relevance otherwise. Did you intend to go into the Billionaires Boys Club other than those Oziel testimony? Ms. Abramson says, well, first of all, Oziel never testified to Billionaire Boys Club. Court says, I know that. We already said that. Mr. Khan says, offhand, I believe that we intended to do it only through, no, actually, there is another way of getting to the Billionaire Boys Club, and that is to conversations the defendant had with Craig Signorelli. I believe he indicated that in his first trial, he indicated that he had conversations with Craig Signorelli about setting up some sort of a business in which each of the participants, and there would be 4 in number, would be able to earn one of $2 million per year, and he acknowledged that this idea was similar to the concept of the Billionaire Boys Club. Ms. Abramson says, so what? My response to that is, so what? How is that relevant to anything? Obviously, the people are going to try to link that by telling the jury that BBC, as far as in this convoluted way, without Dr. Oziel testifying to confront my client. The court says, wait, you don't know that, because Ms. Abramson says, trust me. So the whole Billionaire Boys Club, I don't know if you remember that. There was a movie called Billionaire Boys Club about a guy, a young man who shoots and kills his father, who was, I think, molesting his girlfriend or something. I don't even know. But it was some movie that was popular around then, like a made-for-TV movie. And for whatever reason, they try to say that was, that Erik was somehow using that movie as inspiration or whatever. But really, it was this other thing that he was doing with his friends on earning $2 million per year, whatever it was. Some business thing that they set up with Craig Signorelli that they call Billionaire Boys Club, which there is no anywhere a real definition of it written anywhere or whatever. So this is what we have to go by. And even if that does exist, even if, he did have this Billionaire Boys Club, what does it matter if Ms. Abramson is saying? How is it relevant to everything on anything? Obviously, the people are going to try to link it. Court says, you don't know that. She says, trust me. The court says the subject matters involving Oziel. It's been ruled at this point not admissible unless there's a ruling contrary. Ms. Abramson says, but beyond that, the whole concept of the court may recall, we were not allowed to ask Brian Eslamenia about his brother and what his brother was doing in prison and what the circumstances were. And there were no questions of him about, there was one question. The prosecution asked him about whether he ever discussed his brother's murder with Erik Menendez, and he said, or whether he had ever seen a movie made, without identifying what case it was. He was asked whether he had ever seen or discussed a movie made about his family with Erik Menendez, and he said no. But we were not permitted to talk to him in any detail about what his brother was doing in prison. But what the people would know, or what the people would now like to do is to use the BBC from Dr. Oziel's testimony, which Dr. Oziel doesn't know the meaning of, link it up with this conversation with Craig Signorelli, where it was Craig who says on the tape, like the Billionaire Boys Club, not Erik Menendez. And then, no doubt, try to bring in movie listings to show then the Billionaire Boys Club. This is just exactly where we ran around in the last trial. And we object to that whole thing as irrelevant under 352, unduly prejudicial, that they cannot prove that that's what was said to Dr. Oziel because he doesn't even have the information. That talking on November, was it the 29th, to Craig Signorelli about setting up a business in the context of having just talked about a screenplay is not relevant to anything in this case. The only potential relevance is if Erik Menendez had told it or admits that he told Dr. Oziel that the idea for this, the killing of his parents, came from watching a movie, a thing that he has always denied. And what movie it was has never been provable through Dr. Oziel. So to bootstrap that he knew about something called the Billionaire Boys Club or thought about a business with such based on that activity and bootstrap that back to give meaning to what the non-appearing Dr. Oziel claims was told to him is unduly prejudicial and very little probative value, none, in fact. And we would object to any of that subject matter being gone into, particularly given the way that they were precluded from eliciting from Brian Eslamania, which I would have elicited had I been permitted, that his brother killed his father, that he believed his brother was innocent, that he was very upset about the movies that were made, that he knows for a fact that Erik Menendez never saw such a movie because they discussed it after the time of Erik's parents being killed. Ooh, that's interesting. We didn't know that. The movie was being rerun, and Brian Eslamania was claiming about how inaccurate it was and had a conversation with Erik Menendez where Erik indicated that he had never seen such a movie. So this movie is based on the Eslamania family, the crime, the brother killing the father, I guess. Um, so that's interesting. But that's really where our made-for-TV movies came from, were like court cases and stuff. We had a lot of made-for-TV movies back in the 90s. And none of that was gone into with him. And I don't see that. And that's what we'd be in the position to prove, to show that Oziel's information was faulty, if that's what his information was. The court says, all right, well, first of all, obviously, most of what you're talking about involving Mr. Eslamania is irrelevant and doesn't have anything to do with his testimony, and that's not why it was permitted or not permitted. Ms. Abramson says, I'm only indicating as an offer of proof, Your Honor. The court says, other than whatever your client might have told him about having or not having seen a movie, the rest of what you said about Eslamania is totally irrelevant and has no application whatsoever to this current discussion. I don't know why you brought it up. It actually has a huge relevance if we're talking about this movie, The Billionaire Boys Club, and trying to pin it on that's what inspired Erik, when we have discussion between Erik and Eslamania that Erik never even saw the movie. How is that not relevant, Judge? What a freaking wackadoo this judge is. He is totally ruling in favor of the prosecution nearly every time. I would say about 89 to 95% of the time that he's ruling in favor of the prosecution. But as far as the BBC and reference to the movie, first of all, I don't recall that this was referred to in Signorelli's testimony. I think it came out more in cross-examination of the defendant or playing of the tape recording of the conversation between Signorelli and the defendant at the restaurant. Ms. Abramson says, I think the tape, that portion of the tape, in fact, was not played. In fact, we never played the tape, Your Honor, because it was so hard to edit. Court says, okay, well, something came out towards the end of the trial about it. Are you saying the defendant testified about that, Mr. Khan? Yes, Ms. Abramson says, he was cross-examined. Mr. Khan says, my notes indicate that on cross-examination. Ms. Abramson says, over objection. Mr. Khan says, at the very end of his testimony, if we have volume 104. Ms. Abramson says, you have a page cite? Mr. Khan says, yes. May I see it? Ms. Abramson says, well, don't you tell us or why don't you tell us and we'll see it with you. What was the page cite? Mr. Khan says at 17287. They all pause to find it. Mr. Levin says 285, line 6. Ms. Emerson says, well, no, it comes out here, 17287. This had to do with cross-examination by Mr. Kuriyama concerning part of the conversation between Erik Menendez and Craig Signorelli. Mr. Kuriyama was asking him about wanting to form a group of people, and it was Craig Signorelli saying to Erik Menendez and this is what Mr. Kuriyama asked. Do you recall Craig Signorelli saying to you, kind of like in BBC? And then Erik Menendez was asked about his answer on that tape, kind of like in BBC. But that, it's just everybody here. He was asked if he made that statement on the tape. Mr. Levin says, look at 291. Samerson says, wait, it goes on. Then 287, Mr. Kuriyama asks, what did you mean by the BBC? There was an objection. It was overruled. The witness said, that's what Craig said. And then he asked again, what do you mean by that? And then the witness said, the Billionaire Boys Club. And you agreed with him. This is like the Billionaire Boys Club. What did you mean by that? He's trying to get the definition of BBC. And then on what was on 17291, Mr. Levin says, look at 24. Ms. Abramson says, okay, those are the references, Your Honor. So that's how it came out in cross-examination having to do with a portion of his tape-recorded conversation with Craig Signorelli. Mr. Khan says, so the sum and substance is that Craig Signorelli, essentially this plan that you have about 4 people getting together and making $1 or $2 million a year, is that kind of like the BBC? And the defendant acknowledging, yeah, that's like the BBC. So here we have a defendant who kills his parents and gets their money and intends to set up something like the BBC. Ms. Amerson says, so what is my response? First of all, he didn't get their money. And second of all, so what? Court says, all right, what is the relevance of this as far as reference to the BBC, Mr. Khan? Mr. Khan says, well, I think that, again, it goes to the motive for the defendant to commit this crime. If he's acknowledging to Craig Signorelli sometime after the killing that one of his plans is that he is thinking of forming a group of 4 people and they're going to make $1 to $2 million a year based upon a concept similar to the BBC. The court says, what concept was that? Mr. Khan says, well, I think that's suggestive of cross-examination. This is the defendant's word, like the BBC. It's not the defendant's words, for Christ's sake. These are ridiculous arguments. So the question then is, what was the defendant referring to when he indicated that he had a plan of setting up something similar to the BBC? Ms. Amerson says that's sliding off the wanting to ask about it with respect to Dr. Oziel if they want to ask him. Did you, on November 29th, have a fantasy idea or have an idea about setting up a business with 4 of your friends? Fine, but there's nothing relevant about BBC. I mean, nobody even knows what the BBC was doing. The supposed BBC was doing. The court says, all right, to the extent that there was something, this is not a situation where the prosecution comes out of the blue and says, oh, there are 4 of four of you young men, you wanted to do something. Isn't that like the BBC? And then confronting a witness or a defendant on the witness stand with that. This is a situation where the defendant and his friends were using the words, the letters. So I agree with the prosecution that they're entitled to ask the defendant, what did you mean by that? Of course. Of course. The judge is like, yeah, of course. I agree. Let the prosecution get into it. Ms. Abramson says, except that is the case. The court says what his answer is, his answer is. What his answer is, but he's certainly entitled to ask. Ms. Abramson says, but it opens up the notion that there's another murder case. We don't know what the jury knows about that murder case. It's not just an investment club, so it has prejudicial import, which is not relevant. The court says, I'm not going to let the prosecution go into their understanding of the BBC. Ms. Abramson says, you don't have to. We don't know what the jury understood about it. That's the problem. Court says, well, the defendant used that, and he's going to have to explain what he meant by it. No, he didn't. It wasn't his words. God. The only thing that would appear to be relevant based on this new offer that it goes to motive is that he wanted to set up a business that it took money to invest in, but whether it's like the BBC or not like the BBC has no relevance except to paint him with the brush of the other murders. That's what the purpose is. To say because Craig Signorelli used the word and Erik said, yeah, like that, but not like that he then has to explain and has to be painted with the brush of the Billionaire Boys Club. The court says, now you are moving from the objection of so what to the objection of undue prejudice? It's both, Your Honor. The so what is the relevance part of the undue prejudice analysis under 352. First, you have to look at the relevance, or is it so what? And then you have to look at the balance. Then you have to balance the relevance. The court says it is a so what. It is a what, not a so what. Okay. Mr. Gessler says, now that's a what. Mrs. Abramson says, how heavy a what is it? Is it 100 watt or a 24 watt? Now, Mr. Gessler says, I'd like to be heard, Your Honor. Yes, Mr. Gessler, says the court. Under 352, which counsel points out, it has a lot of connotation because of the movie and publicity given it. This is obviously 2 months after the homicides here, so there's no 3 months here. There's no part of being like BBC or not being like BBC, which includes killing your parents. They've already been dead, and that's the major connotation BBC carries is killing somebody's parents. That is not, the prejudice here of that connotation to the jury of like BBC, I think outweighs any probative value that the court found on the relevance. Court says, I must have thought differently in the first trial because it apparently came in. Mr. Gessler says it came in because there had been so much talk about the BBC in other contexts in the first trial from Oziel as to whether it meant British Broadcasting Company or none of that is here. The court says, I do recall. I was just joking. There was a part of it that tied in to Oziel's testimony. Mr. Gessler says, we do have a co-defendant here. I don't remember if that part of Erik Menendez's testimony was before both juries or just his own. Court says all of Signorelli was only in front of his jury. Gessler says, we also have that aspect with Lyle Menendez before this particular jury. Court says, all right. How do you deal with that, Mr. Khan, assuming Erik Menendez makes whatever explanations he gives to BBC, and we have to assume he's not going to say a group of young men planning to kill people and kill their parents and things of that nature, but something such as investing in whatever they were investing in, whatever they were doing. Now, how do you ensure that the jury doesn't draw the prejudicial inference that the BBC is a group of murdering young men? Mr. Khan says, we have no indication at this point, that the jury is going to draw such an inference. There is no indication the jury has any knowledge of this area whatsoever. I'm sure they're going to be guided by the limitations which are come out through the evidence. In other words, if the defendant indicates that it has nothing to do with a group of murdering young men, it simply has nothing to do with a group of investing young men, and nothing more is said about it, then there is no reason for the jury to make the link and say just because the defendant was using that as a model for his investment activities, that therefore he was also intending to kill his parents, because based upon the criminal activities of the people who were involved in that separate incident. So I don't think simply because the defendant might refer to that group necessarily means that he incorporates all of their ideas. Court says, well, the only reason you would be asking it would be with the hope that he would say something like that. If he didn't say something along the lines you're talking about, that this was a group of, I was asking my friends about being involved in a group of high rolling kids who were out there killing their parents and killing other people. If he didn't say that, what is the relevance of his reference to BBC? Well, again, I guess the main problem I have is we can't anticipate in a vacuum as to exactly how he's going to respond and what follow-up questions I may have in this area. And we can't draw an outline of let's give the defendant the benefit of the doubt as to how he's going to answer not only that question, but every follow-up question that the prosecutor might ask dependent upon that question, based upon the benefit of the doubt in regard to all the entire line of questioning. Where are we going to be? We really can't do this in a vacuum. It seems to me that if the defendant said in his prior testimony that he, in fact, was planning something along the lines of the BBC and he was going to use his money to set up something like that I'm entitled to ask the question in that area and then again see where we go from there. Perhaps depending upon the answers that are given, the defendant may answer in a way that is beneficial to him. Perhaps he won't answer in a way that is beneficial to him. Perhaps I'll come up with a question that will make it more relevant than we can anticipate at this time. All I'm saying is, I don't think we can decide in a vacuum where we're going to go at this point. The question before us right now is, can the prosecutor ask him what he meant? And since he testified to it previously, it seems to me the prosecution should be able to ask that. These lawyers are long-winded. Ms. Abramson says, obviously, what Mr. Khan is saying is nothing. He doesn't know what the jury knows about this, and he obviously intends to ask questions about the murderous young men in the Billionaire Boys Club. That's completely prejudicial and inadmissible. It's ridiculous that he's arguing this except to signal to the jury, BBC, and hope they remember that this is a group of people who murdered. They specifically want to try to bring out the inference that when Craig Signorelli said, like the BBC, and Erik Menendez said something like it, that he had in mind murder, and that's absolutely impermissible. Mr. Khan says there is no reason the jury would say that because he intended to model some investment activity based upon BBC like that. Therefore, he intended to commit the further murders. Exactly, says Ms. Abramson. Mr. Khan says, that's not the issue before us. The issue is why was the defendant planning to do something comparable to the BBC, and what specifically did he mean by that? And I think that is a legitimate area of examination since these are his words. He was the one. This is his idea, not ours. This is his idea. And if he said, I intend to do something like some other criminal agency, we could ask him, what did you mean by that? Maybe you intended to incorporate the activities of that agency. Maybe you didn't. What was it about that criminal agency that caused you to want to model yourself after them? In his words, we should be able to ask him what it means. The court says, so you're saying if the conversation was just like the mafia? Exactly, says Mr. Khan. Court says, then you would ask, why did you say that? Or what did you mean by that? Mr. Khan says, exactly. He could say the only aspect about the mafia that I was going to intimidate was their investment genius, not their criminal tendencies. And that's the end of it. But since he brought it up and since he said, I intend to do something like the mafia with some other criminal agency, we should be able to ask, what do you mean by that? The court says, let's hear a response. Mr. Gessler says, I think we know from what Mr. Khan has said that will not be the end of it. All we were going to do is to invest in stocks and bonds and use the same broker that they did or something like that. That will not be the end of Mr. Khan's questioning. He will say, were you going to kill people? Were you going to do other activities like the members of the Billionaire Boys Club and get us off of the real tangent? All of which could be a 352. And the harm would be in the asking of the questions, not the court then sustaining an objection and saying disregarded. And so that I think this whole area is 352 using the initials BBC at all. Certainly, any follow up question are 352, and it certainly is prejudicial to Lyle Menendez in this context beyond any possible probative value. Ms. Abramson says, first of all, in the context of a confession that they're confronting my client with pieces of, it's clear they're just talking about people investing money for friends, trusted friends, investing money together. There is no suggestion of anything else. So nothing adds to that intentionality of on the part of my client by adding in BBC except this murderous side. And I contend that mafia is even more clearly a purely criminal enterprise and that it would be objectionable even if the defendant had said clearly mafia because future crimes or activity to commit future crimes, whether the defendant indicates it or not, just like prior criminal record, is not ipso facto admissible. On the contrary, the basic rule is they are not admissible under 1101, and there has to be some exception to admit them. So, I mean, to show that this is a way to get into other criminal activity, it's absolutely impermissible. It has no value to his prosecution except an impermissible value to conjure up theories of murder and then to try to connect that back. We still haven't heard where we stand on the BBC reference by Dr. Oziel, which he didn't know the meaning of. But that's what they want to do is link the two together for murderous purposes, not for stocks and bond purposes. The court says, all right, anything else? No. All right, in this situation, she who argued last argued best. As far as the issue is concerned, at this point under 352, the relevance really has probative value, but is subject to misinterpretation by the jury and potential for prejudice. This is actually a win for the defense, in that the jury would relate it to their understanding of what BBC Billionaire Boys Club was and would be a potential confusion and potentially prejudicial. And the probative value is substantially outweighed by its potential for prejudice. The court analyzed it differently in the first trial, as Mr. Gessler correctly points out, because there was the predicate and or reference to BBC in Oziel's testimony and a tie-in and connection by that testimony being attributed referenced to the BBC through Oziel's testimony, being the genius of the plan to kill the parents. And then there was, throughout the first trial, further efforts by the prosecution culminating in some testimony by Detective Zoller about the BBC and the movie, and all of that was a predicate for the type of questioning that did come in during the cross-examination of the defendant. Although perhaps Zoller's testimony came in after the defendant had completed his examination, but there was a predicate of Oziel's testimony before that. So certainly reference to the plans to spend and invest and things of that nature, but at this point I don't see the probative value outweighing the potential prejudice in reference to the BBC, so the prosecution won't be able to use that at this stage. I'm not precluding it from being brought up if Oziel and his testimony is presented, obviously. All right, what else then? Mr. Gessler says, Your Honor, at this point, Erik Menendez is requesting a 5-minute bathroom break. The court says, okay, and will resume at 11:30. Ms. Abramson says the next item would be page 8, Your Honor, the matters that the court had limited in the first trial under 402, vis-a-vis what Oziel himself couldn't testify to. Then a recess was taken. The court says, let's resume with the hearing. What was the next item that the defense wanted to argue? Ms. Abramson says the next item, Your Honor, had to do with what's on page 8, Roman numeral 8. The prosecution should be precluded from asking on cross-examination questions which the prosecution was not permitted to ask Dr. Oziel at the last trial. If the people don't intend to go into those things, that was the subject matter. It was the end result of a lengthy 402 hearing we did with respect to Dr. Oziel's testimony, where the court made certain rulings pre-trial about things that appear in his notes that he was not permitted to testify to at the trial. And then that included that sociopath discussion that we do cite specifically in the moving papers. I apologize that I don't have before me the transcript of that 402 for each and every line that the court ruled they couldn't use. But my vague recollection is there were only 4 or 5 items in the Oziel notes. One of them had to do with the court, uh, may recall. We took live testimony from Dr. Oziel for clarification on some of those things. One of them had to do with an opinion that he put in the notes. Court says, let's stop. Are you going to bring this out? I don't think it's necessary to, says Mr. Khan. I don't think it's necessary to get into the word sociopath as far as cross-examination of the defendant. Ms. Amerson says, that's fine. With respect to other matters, I don't know what the people's position is. For example, there was that speculation by Dr. Oziel that having to do with Lyle thinking that he was king, having to do with Lyle thinking that the king was dead and he was going to be king. I don't know if the court recalls that. Huh? Court says, where is that in your motion? Ms. Abramson says, it's not specifically laid out, but it's in the hearing that we had with Dr. Oziel. The court ruled we are assuming the people are aware of the court's prior rulings limiting evidence. The court ruled Dr. Oziel testified that was just his thought. It was nothing that the defendant said. Court says ultimately it came in towards the end of trial. Abramson says no. That didn't come in. The court says, yeah, it did. During the testimony of one of the defendants, it came in. The sociopath came in. I'm not talking about the sociopath. I'm talking about killing the king. He was now king. I think that was in the notes of November 2nd. The court ruled that Oziel couldn't testify to that. There was information. The court says, that I don't recall. Are you bringing that out? Mr. Khan says, no, I wasn't planning on bringing out anything about the king. Mr. says, if the people are going to limit any questioning that they choose, whether they have the court's authority or not, at this point, if the people are going to limit the questioning of our client based on what Oziel actually testified, that was not objected to and stricken, then we're fine. It has to do with things that the court had ruled before the last trial they could not elicit and did not elicit from Dr. Oziel that this particular paragraph applies. So if they are self-limited to testify or to what he has testified to, we don't have this problem. Mr. Khan says, well, I don't know precisely what counsel is referring to. The court says, I don't either because we're talking about Oziel possibly not being a witness, so we're talking about cross-examination of the defendant. Ms. Abramson says, yes, and what I'm saying is they should not be able to confront the defendant with notes, Oziel's notes, that this court previously ruled even Oziel couldn't testify to. That's what I'm talking about. And what I will do is I will put out those transcripts and give the court the specifics on Monday. The court says, all right. Ms. Abramson says, if the people were aware of this and just could indicate no, we're not going into that. Fine. Since they're not saying that, I'll have to pull it out. The court says, I have no recollection of the hearing, even as far as what the issues were that you are referring to. Ms. Abramson says, I know what that's like. There's so much more. The court says, I just don't have any recollection of it. So it occurred before Oziel's testimony. I just don't recall what it was that he was not permitted to disclose in his testimony that then never was presented. Ms. Abramson says, I think in volume 58, I'll pull it out. What is the next issue here? Ms. Abramson says the next issue had to do with the prosecution shouldn't be allowed to ask questions about how much time Mr. Menendez spent preparing for his testimony, working with his counsel, or with his experts because it would, excuse me, dog, stop messing with my mouse. Sorry. They shouldn't be able to ask those things because The only purpose they'd have in doing it is an improper purpose. It suggests collusion and fabrication with experts or attorneys, and that invades the attorney client privilege and his constitutional right of counsel and that sort of thing. The court says, what is the people's position on that? Mr. Khan says, well, I didn't necessarily intend to inquire into specific preparation with counsel, but I think I can come up with some questions concerning whether or not he did, in fact, prepare for his testimony. Saberson says, well, I don't think it's appropriate even to ask him. Obviously, he's prepared. Every witness is prepared. I don't think it's relevant to ask someone if you're prepared for your testimony and what does prepare mean and what's the relevance of it. I kind of agree. Like, it almost is like an insinuation that he did something wrong when you ask questions like that. The court says, well, it depends on the type of question that's asked. When this issue arose in the first trial, the problem I saw was the people's proposal just asked how much time did you spend preparing, and it was ambiguous. What is meant by preparing? In theory, every time the defendant has met with any lawyer, it's preparation, so it would be meaningless, really. Also, the people would be stuck with whatever answer the defendant gave at that time. I spent 50,000 hours or 5 hours preparing. People have no way of refuting that, really. But as far as what he did and materials he read and witnesses he spoke with, things of that nature, certainly I don't see how that could be any different than any other witness as far as cross-examination. Abramson says, they're privilege issues. The court says, that's not privilege who he speaks with. It's the content of the communication, not the fact that there was contact. Ms. Abramson says, the other concern we have is not specified in the motion. As the court may recall, in the previous trial, the prosecution tried to implicate Mr. Mones somehow in Mr. Mones' book, and we would object. And the court ruled that those matters were not appropriately gone into by the prosecution. Mr. Mones was a lawyer for the defense and covered by the attorney-client privilege. Oh, hold on. Sorry, I don't know where I was. The dog it looked like the puppy, was looking for a spot to go or needed to go out. So I had to give him a potty break. And I don't remember where I left off. So I'm going to start with Ms. Abramson at the top. And just so you know, we are just about at the halfway point with this argument. This is the full day. This is all they do is just argue. So there's no testimony today. It's just arguments. Starting with Ms. Abramson. The other concern we have is not specified in the motion. As the court may recall, in the previous trial, the prosecution tried to implicate Mr. Mones somehow in Mr. Mones' book, and we would object. And the court ruled that those matters were not appropriately gone into by the prosecution. Mr. Mones was a lawyer for the defense and covered by the attorney-client privilege. The people have no evidence whatsoever concerning his book. The court was even given a copy of the book to pursue it. We would object to any reference to Mr. Moan or his book. The court says, did you intend to refer to Mr. Mones? Mr. Khan says, if he was one of the witnesses he met with in preparation for his testimony, that is something that would come up. The court says, well, Mr. Mones is a lawyer. Mr. Khan says, I'm not sure that was his capacity when he met with the defendant. If he was meeting as an attorney, I don't think he was his attorney at the time. The court says, well, not an attorney in court, but retained as counsel or represented to the court as that, at least at some point in the past, that he was retained as counsel. Ms. Abramson says, correct. Mr. Khan says, well, if I'm precluded, I won't do that. The court says, certainly with reference to witnesses he has spoken with and materials he's reviewed and all sorts of things, it's all subject to cross-examination. Ms. Abramson says, but not conferences with his lawyers, Your Honor. Not the content of any communications with his counsel. Ms. Abramson says, well, even talking about meeting with Mr. Mones has no relevance or meaning unless they're going to try to bootstrap into Mr. Mones' area of expertise. The court says, we're not talking about Mr. Mones. He's not going to refer to Mr. Mones in general. The fact he's spoken with counsel. Ms. Abramson says, I think it raises an inference of wrongdoing when there is none. He's entitled to talk to his lawyers as often as he likes. The court says there's no inference of wrongdoing. Well, then what's the relevance? Court says the relevance is he spoke to his lawyer. That's all. Come on. Really? That's your legal argument? Ms. Abramson says everybody speaks to their lawyers. That's not relevant. I'm with it, Ms. Abramson. Court says that's not why it's the subject of a claim of confidentiality. It's not an infringement of his Sixth Amendment right. Ms. Abramson says I can lead to an improper inference that somehow there's some wrongdoing. The court says he's already said he's spoken to you. He's referred to you several times. What does that prove? Ms. Abramson says the reason he indicated that he spoke to me and told me something early in the genesis of the case is one thing. To ask how many times did you meet with your lawyers, or when did you meet with your lawyers, or how much preparation time, I think that's to suggest something wrong when he has an absolute constitutional right to meet with his lawyers, and his lawyers have an absolute constitutional obligation to provide effective assistance by making sure that any witnesses, including the defendants, are prepared before they testify. The only reason the prosecution would elicit this is to suggest improperly that there's something wrong with spending a lot of time preparing somebody to testify, and that's why we think none of this should be gotten into. Stop bumping. Nope. He likes to chew cords. And there's a cord that my earbuds are on a cord, and he likes to chew on them. And that's why we think none of this should be gone into. Mr. Gessler, says the court. Mr. Gessler says, I agree, Your Honor. On behalf of Lyle Menendez, as to the witness, Erik Menendez, that inquiry should not be allowed to be gone into by the prosecution as to what attorneys he spoke to, the amount of time he spoke with them, much less, of course, the subject matter that was covered, because, again, the only possible relevance could be that there was something improper in spending X number of hours with your lawyers, almost causing the lawyers to get up on the stand and say, no, it wasn't improper at all, which of course we can't do. I think it's a violation of the Sixth Amendment to allow them to ask that particular question as to the amount of time and lawyers that they actually spoke with, as well as attorney-client privilege. Ms. Abramson says, what I think it does is puts lawyers in the untenable position of where you don't prepare your clients, so the inference can't be raised that their testimony is rehearsed or fabricated, and that violates your obligation of effective assistance of counsel to your client. Court says you made that argument in the first trial. That's a bogus argument. That's not going to inhibit anybody from doing their work. Ms. Abramson says, I don't know if it's bogus. Court says it's bogus. Just because you refer to the Constitution and an attorney, link them together, that doesn't necessarily make a valid argument. What a dick. Ms. Abramson says the point is that if you don't prepare your client in order to protect him from these kinds of things, you've failed in your obligation. And if you do, it's always the lawyer's choice, never the client, how much preparation you're going to put in. Then your client gets penalized for the fact that you spent time preparing him. So, what's the ultimate relevance of the fact that he's prepared? Mr. Khan asked yesterday repeatedly whether in 6 years he's had time to think of things. That's a totally rhetorical, argumentative question. In 6 years, we all have time to think of things, until he got that point across. But to implicate the lawyers somehow in it, I think raises impermissible inferences. Court says, well, as I said the first time, the reference to the word preparation and what did you do to prepare and how long did you prepare has within it ambiguity, because anything the defendant does is speaking with anybody, his lawyers or others, can be regarded as preparation. So just asking the question, what have you done to prepare, is a meaningless question. The prosecution is not permitted to inquire into subject matters of conversations with counsel that would infringe upon the attorney-client privilege. As far as the meetings, the fact that he has spoken with his attorney before he testified, I don't think that is an invasion of the right of attorney-client privilege or in any way infringing on any constitutional right or right of communication in private with counsel. Ms. Abramson says, does it infringe if they ask in these, did you meet with counsel before you testified? And was your testimony discussed? That's infringing on it right there. That talks about what the subject matter of the discussion was. Court says, okay. If they can't ask that question, then what's the relevance of it? Did you meet with your lawyer? Court says, listen, we're spending a lot of time arguing over something that is going to be obvious to the jury anyway. The fact the prosecution asked that question is not prejudicial and doesn't infringe on any right of the defendant to ask whether you met with your lawyers before you testified. The jury sees these meetings during the course of examination when counsel goes up and whispers to their client on the witness stand. What? When does a lawyer ever go up and whisper to their client on a witness stand? It's hardly a secret. I don't see this as needing further discussion. You're not even supposed to talk to your client when they're on the stand, right? Like, not about their testimony. That was a weird statement. As far as the other objections here, what else? Ms. Abramson says there's two other things that aren't written here, Your Honor. Since the court's already ruled on the burglaries, number one has to do with Mr. Signorelli, and we don't know if Mr. Signorelli is under subpoena or not. My last intelligence on that issue was that he was not, and we would object to any cross-examination of Erik Menendez concerning any statements either made to Signorelli directly, ostensibly, or anything on that tape. We did not present in direct examination anything having to do with statements made to Mr. Signorelli or meeting with Mr. Signorelli. We haven't opened any doors on that. Court says, what is your position on that, Mr. Kahn? I think that the prosecution can properly ask the defendant about matters relating to Mr. Signorelli, including conversations with Mr. Signorelli. Whether or not we serve him with a subpoena at this point is not the issue. He's a cooperative witness. We have no problem with getting him into court, and we would subpoena him if that's necessary. The fact that counsel did not choose to go into those matters with him doesn't prove that we don't have a legitimate area of impeachment concerning Mr. Signorelli. The court says, well, are you indicating that you would be going into conversations Signorelli had with the defendant concerning the defendant about that? Yes. All right. This falls within the same category as the Oziel testimony that we discussed earlier, does it not? Yes, we could subpoena him too. The court says, well, I want him under subpoena before questions are asked, number one. Number two, likewise, before you asked about statements made to Signorelli, a brief filed by the prosecution on this subject so that if you ultimately do not call Signorelli as a witness, then I want to be in position to evaluate the defense indicated objections or requests for remedy, whether it be mistrial or some lesser sanction. Ms. Abramson says, the other matter, too, Your Honor, is above and beyond that. With respect to the tape-recorded conversation, there was a great deal of litigation and negotiation at the last trial. There's many things on that tape that were ruled inadmissible in the last trial, and I want to know if the people are going to choose to abide by the court's prior ruling, if they're allowed at any time to go into what's on that tape, whether they are intending to go beyond what was permitted in the last trial to be questioned of Mr. Menendez concerning that conversation. Court says, well, certainly the content of the tape recording, to the extent that it was ruled admissible in the first trial, since it has his voice on it, the defendant's own voice, doesn't suffer from the same problems as questioning the defendant about things that Signorelli testified to in the first trial. So as far as going beyond matters that the court ruled were admissible, did you intend to do that, Mr. Kahn? Mr. Kahn says, offhand, I'd have to check my notes to see what was ruled inadmissible. So I can't really say whether inadmissible as a matter of cross-examination you mean as opposed to our case in chief. Court says, yes, cross-examination. Ms. Abramson says, there was material that was inadmissible on cross-examination, including screenplay material and other conversations. There's conversations about Lyle and Craig Signorelli being afraid of Lyle. That, I think, need to be litigated before any of that. There's conversations about Lyle and Craig being afraid of Lyle that I think need to be litigated before it's gone into. So there's conversations about Craig being afraid of Lyle. Mr. Kahn says, yes, we intended to go into some of that material. The court says, okay, so anything that was the subject of a ruling of the court in the first trial, ruling is not admissible, would not be permitted here unless you request a hearing and one is conducted before you ask the question. So anything he ruled inadmissible in the first trial, he's not allowing in this trial unless you make an offer of proof. He wants a hearing for it. Ms. Abramson says, I think co-counsel now have objections, Your Honor, because that tape never came in front of a Lyle Menendez jury, and there were materials having to do with Lyle that I can't remember now if they were excised or not. But I think, Mr. Gessler says, much of it was. At least some of it was excised, having to do with Lyle. The rest did not go into a motion concerning Lyle because, as counsel says, it wasn't coming before his jury anyways. Court says, all right, well, if there are references to the co-defendant that are brought out in materials involving Signorelli, these tape-recorded conversations, again, the prosecution is to give notice to the defense before questions are asked. Ms. Abramson says the other thing, too, Your Honor, is just a general hearsay objection to that tape recording. There's nothing confessional on that tape. The only thing on that tape that might rise to that level is an acknowledgement by Erik Menendez that he made some kind of admission to Signorelli in the past, and then his statement on that tape that it wasn't true. And other than that, the discussions really don't rise to the notion of admission or confession as to meet an exception to the hearsay rule, whether it's being used on cross-examination, direct examination, or any other way. Court says, all right, I can't. Ms. Abramson cuts him off and says, I think the only reason some of it came in last time was because of Erik Menendez's testimony concerning statements made to Craig Signorelli, because Craig Signorelli was called as a witness in the people's case in chief. I mean, as the court knows, things become relevant based on things that have preceded them in this case. Since the only reference to Signorelli that's been made in this trial is that he's a burglar, that does not make the matters on that tape admissible in the same way, even those that were admissible. This is so, for a lawyer to be so on top of her stuff. Like, I am so impressed with Ms. Abramson, and she's so on top of it. She's on top of her facts. She knows what she's doing. She knows this case in and out. She knows what was testified to in the first trial versus what was testified to in this trial. She can tell you without even having to look, probably. She's so on her game in this trial. It's not even funny. And it makes me saddened to know that she gets cut off a lot or told no a lot by the judge when she makes such excellent arguments. The court says, I thought this was a grand theft. Ms. Abramson says, we've been talking about it as a burglary. I see, says the court. She says, we'll just call him a thief. My client's a thief. He's a thief too. The court says, I can't rule in the abstract on these matters unless I hear what the questions are on Signorelli. What else? You had something else? Ms. Abramson says, yes. The other thing is, well, two more things. Number one, the court says, we're going to do this at 1:30. We are? It could be real fast. Court says 1:30. I also want to discuss finalizing things with Mr. Rand. So Rob Rand, who wrote the book Menendez Murders, excellent book, and really talks about the first trial in depth and the facts of the case. Ms. Abramson says, exactly. He became a witness when one of the people that he interviewed needed to be impeached, and he had impeachment material in his notes from his journalism. So he became a witness in the first trial. Sorry, I couldn't think of the word. The court says, and also find out what the people's current position is on the psychiatric examination of the defendant, so we can perhaps discuss that this afternoon. Ms. Abramson says the other thing is the shotgun. We want to talk about trying to put it in his hand. Then they go on break. They come back. The court says, the jury is not here still. Court says, okay, are we ready to resume? Mr. Levin says, yes, Your Honor. Court says, what is it you would like to talk about now? Any particular priority of things? Ms. Abramson says, Judge, I want to ask you a question to see if your memory is better than mine. I couldn't find that we had ever marked an authorized version, an agreed upon version of the 1129 tape transcript. I know there had been rulings about what parts of it were admissible and what parts weren't. I know there was a lot of negotiating between Mr. Morrissey and Mr. Kuriyama to come up with a final agreed upon version, but I can't find it in the exhibit list if there ever was. Court says, if it's not on the list, then I have no You have no recollection of it? Someone provided me with a copy, says the court, of it more than one occasion because I misplaced one, but I don't know if it was marked as an exhibit. Ms. Abramson says, see, this prosecution team had proffered it, but I don't recall now if the version they proffered was the original version with all excluded things in it or was the version following the court's ruling. So I'll have to find one over the weekend and see if I can find that final agreed upon version. Court says, Ms. Abramson says, I know, and I don't remember now the extent to which Signorelli was asked about it when he testified. Court says there was some questioning of it. Ms. Abramson says there was some questioning of him, and then there was some questioning of Detective Zoller about it as well. And your client as well, says the court. Yeah, says Ms. Abramson. Court says, okay, let's then move on. What else then in regard to the motion to limit the scope of the prosecution's examination? Ms. Abramson says the no shotgun display argument. What's the argument, says the court? The argument is, the court says, let's go the other way. Did the people propose to do this in any way? Yes, Your Honor. Ms. Abramson says, do I know what he thinks or not? The court says, okay, what is your argument? Ms. Abramson says, we think it's unduly prejudicial for a number of reasons. First of all, this isn't the gun that was used. Second of all, there's been no issue raised about whether he did fire the gun, could load the gun, did load the gun. There's been no technical issues offered by the defense, and there is simply nothing relevant to be proven by having him do anything with that gun. Its only purpose would be a prejudicial purpose to give the jury a vision of him holding such a gun. And there's absolutely no relevant purpose for using it. And it's solely to make him look like a bad person and a threatening and scary person by holding the gun. The court says, okay, people's response. She's absolutely right that it's so prejudicial. It's so prejudicial. And I can't even believe that the court is just like, yeah, whatever. I don't know. Hold on. Let me fix my mic stand. It just moved it. All right. Its only purpose would be prejudicial and give the jury a vision of him holding the gun. The court says, okay, what's the people's response? Well, I don't want to be in a position here, says Mr. Khan, where I have to reveal every question I am going to ask the defendant on cross-examination before I begin my cross-examination, but obviously this is the case in which the defendant used a shotgun and he testified that he used it in a particular way. He testified that he went into a room, he was firing, he was loading and unloading, and so on and so forth. So he told us a great deal about what he did with the shotgun that was identical to this. They did not in trial one make them hold the guns or pick them up in any way. So just based upon that, I can think of a number of questions I can ask him concerning the operation of that shotgun and how he used it in that particular day. And he could indicate for the jury by holding the shotgun and by identifying his actions and his movements what it was that happened on that day. And I think that I don't know that it's necessary to get into the details of that, but given the fact that it was the defendant who used the shotgun, and this is a similar, if not identical shotgun, I don't see how the defendant can claim prejudice when he was the one who purchased and used the shotgun like this to kill his parents. I just don't see any basis for the prejudice because it's the defendant holding it. That's the prejudice. You're making the jury envision him holding it. So you're putting them in that moment where he's holding it and shooting his parents, and you're using emotion over evidence. Ms. Abramson says, well, I mean, it has absolutely no relevance. There's no issue that having him handle that gun is going to illuminate. There's nothing in issue about it. Moreover, that is not the gun. There has been no foundation laid that the gun operates in precisely the same way as the gun that was used. We, in fact, know that this gun's defective, quite the contrary to the implication. And there's no relevant purpose to have the defendant handle it except to prejudice him in the eyes of the jury. And under 352, if for no other reason, I can see no relevance. But even if there was some magical relevance, he wasn't denied that he he hasn't denied that he did it. He hasn't denied that he could make the gun function. The prejudicial impact of that display outweighs any probative value of having him dance around with it. I mean, the court didn't even want me to handle the shotgun. I mean, I can understand I am a little wild and reckless, but it wasn't loaded. But the court didn't want me to handle it, and I think it's absolutely inappropriate to have the defendant do so. That's not his gun. The court says, obviously, the handling of the gun by counsel and handling it for a particular purpose, demonstrative purpose of a witness is different. For counsel to just walk around with it for no reason doesn't accomplish anything, doesn't forward the progress of the trial. That's not true. If she's talking testimony about the particular gun and the functions of the gun, she could use it to display portions of the gun, point to things of the gun, like this is the chamber, this is the barrel, she can use it to demonstrate, but I guess that's totally different in his eyes. The issue is whether or not this would be appropriate for demonstrative evidence. The court has already ruled, and we've had it on the record on several occasions, that the weapon in question is substantially similar to the weapon purchased by the defendants, and therefore the objection that it's not the actual gun fails because it is substantially similar. The defect, as I understand it, has been cured. The defect had to do with the placement of the dowel in the receptacle that held the cartridges casings more than the 2 casings that are authorized by the Department of the Fish and Game. That apparently has been repaired. It depends on the nature of the demonstration as far as the relevance. Ms. Abramson says, well, under the court says, as far as I can see where certain matters can clearly be relevant as far as the weapon, as far as ejection patterns and things of that sort, as to how the shell casings eject from the weapon. There is no way of establishing that any demonstration here in court would be substantially similar to the weapon in question, or that would relate to the specifics of the weapon used. Did you intend to go into the ejection patterns and how the shell casings were ejected from this particular weapon? No, Your Honor, says Mr. Khan. I did not. Ms. Abramson says nothing else would make any sense either. They're not going to hand him ammunition. If that were an issue, that would be inappropriate. The dummies McCarthy brought stick in the gun. They're not useful. There's nothing he could do with that gun. Moreover, we would object to having him do anything with it as an improper demonstration or improper experiment. We're not under the same circumstances. Court says, well, I'm not contemplating an experiment at this point, but as demonstrative evidence, I think under appropriate circumstances, depending on the nature of the questions, it could be used. So I'm not going to foreclose it at this point. Ms. Abramson says, I can't imagine anything that would be relevant other than handing him the gun to pose. There. He can load it. He can't load it. He can't object anything. He can't fire. He can't do any of the things that might be relevant just because of the circumstances, and to try to make him do any of those things would be an improper experiment under non-similar circumstances. The court says, well, it depends on what is done, and I'm not going to rule on it at this point, but I think as a general principle, demonstrative evidence is permissible, and this is a piece of demonstrative evidence. This judge, this trial could have gone a different way. The brothers could have gotten actual justice and done their manslaughter time and been out 20 years ago. I think something like that. I don't know. They would have been out a long time ago. But yet we have a judge and a prosecutor who are doing these underhanded things, as you can see just from these arguments alone today. Prosecutors trying to admit stuff without bringing the witnesses in to authenticate the stuff, or to basically to avoid credibility issues. He's not bringing those witnesses in like Signorelli and Oziel. But yet he wants to bring in their statements about the defendant. It's not right. All right. But the court says it's evidence is evidence. Ms. Abramson says, it's not just an ordinary piece of demonstrative evidence, Your Honor. I want the court to address the emotional impact of this evidence, which is the only reason the people would be handing him this gun. It's not for demonstrative purposes. They know how the gun works and they can figure out the various ways that the gun can be fired. The issue is, what is the real purpose of putting that gun in the defendant's hands 6 years later? Court says, I'll have to hear the questions asked as far as the relevance of it. I don't see the prejudice. I don't see that there's any prejudicial impact by the defendant holding the weapon. Are you serious? How could it not prejudice the jury? So, in response to your request, the court's position is I don't see the prejudice. Your Honor, I'm asking then this court allow myself and my client to have the shotgun to be able to before Mr. Khan. Court says, yes, I'll let you have access to it sometime today. Mr. Levin says, with my client. Yes, says the court, sometime today, we'll let you have access to it in the courtroom in a private situation. Mr. Levin says, thank you. The court says, okay, what's the next issue? Ms. Abramson says, the Bob Rand manuscript. We're unclear as to whether Mr. Khan was indicating yesterday he didn't intend to use anything from it at all or wasn't intending to use it yesterday afternoon. We still need a hearing on whether that's usable, given the fact that I have no idea what part of the manuscript the people might be contemplating using, but the real problem is whatever they try to use, we can't test the authenticity because Mr. Rand's asserting the shield. So he's asserting the fifth or whatever, his journalistic right to not have to testify about something that he is writing about, I guess. I would assume that's what the shield is. So he can't testify, they can't make him, and because of that, that's a problem. And they want to use the manuscript. The people want to use the manuscript that he had, probably for his book. Court says, all right, did you intend to use the manuscript in your cross-examination of the defendant? No, Your Honor. All right, as far as the protective order proposed by Mr. Rand's counsel, I'll read and consider it. I've read and considered it. I want to hear any objections by either side. I think the defense had no objections. The people had an objection. What precisely is your objection, Mr. Khan? Mr. Khan says, well, I think that the primary focus of the protective order should simply be that we don't disseminate the manuscript to outside sources. So I think that if a court is going to issue any ruling whatsoever concerning that manuscript, the only order that the court should issue is that the manuscript should not be distributed. That's the sole issue before the court, it seems to me. And I think that that is adequately covered in paragraph 1. I don't see the necessity for any of the other paragraphs. Court says, well, if you or the defense proposes to use it in some fashion during the trial, the stipulation or the order, protective order, also indicates that you should make such a disclosure to the court prior to doing so. What is your objection to that? Mr. Khan says, well, I don't really have an objection to that as far as this court is concerned. I'm just wondering why it's necessary for this private property to be asking the court to sign an order concerning how that is to be used in this court. If the court wishes the people to advise the court as to any use that we intend of the manuscript prior to its use, I have no problem with that. I just question why a private party is asking this court for an order to that effect. Court says, okay, well, I have no problem with it and I'll sign it. I have a little problem with some of the remarks of counsel because you talk about double standards occasionally in the court proceedings, and I recall specifically the defense arguing to the court that if there was something in Mr. Rand's book that could be useful in impeaching the witness, Mr. Rand would do the right thing and be cooperative. But you were saying just the opposite in response to if the DA was to use it. Ms. Abramson says, all I know is what Mr. Rand has said, which is that he's asserting the shield as to the manuscript, and I have never gone into the specifics as to whether he would or wouldn't waive it for anything because there's nothing in the manuscript that we intend to use. All I know is the court cuts her off and says, that wasn't your expectation, though, when you made that statement to me earlier. Excuse me? Court says, it wasn't your expectation when you made that statement to me earlier. You felt that Mr. Rand would do the right thing. Ms. Abramson says, well, he's not doing the right thing. Court says, I want to know if there's some understanding that you have with Mr. Rand that you can use that manuscript. Ms. Abramson says, we have no intention of using it. Court says, no. Is there an understanding between you and Mr. Rand that you could use it if there was a question of impeaching the witness? Not that I know of. Mr. Gessler says, only to the extent from the last trial, Your Honor. The court says, what do you mean? No, it's not the manuscript, says Mr. Gessler. Ms. Abramson says, as the court knows, there were certain things that he published. There are certain things that he published in the past that were found by the court not to be included in the shield, having to do with the Donovan Goudreau issue and some Donovan Goudreau tapes. Remember I said he interviewed someone and they had to impeach him? The court says, I recall that. I'm just asking is that what you were referring to, or are you referring to some other incident that that has yet to occur in which a witness would testify in a way contrary to statements made to Mr. Rand, and then you would propose to call Mr. Rand and have some expectation or understanding with him that he would cooperate? Ms. Abramson says, Your Honor, to tell you the truth, I don't know that I was thinking what I was thinking of when I said that to the court. I'll tell you that right now we have no intention of using anything from that manuscript. I'll go one step further and tell the court I've never read it. So I can't tell you there's anything in there I want to use. Those who have read it have not indicated to me that there's anything in there we want to use. And I honestly cannot remember what I had in mind when I made that statement to the court because this is all becoming a jumble at this point. I can barely keep track of what we're doing today. So I was not intending to mislead the court, and I'm sure I had something in mind if I said that, but I can't remember what it was. All I know is that for the past several months, we've had no intention of, the court cuts her off and says, I'll just quote you so you'll remember. Excuse me? The court says, I'll quote you. She says, you don't have to quote me. The court says, this is at 35-955. If the witness, sorry, dog is moving. If the witness admits, Ms. Abramson says, what day was this? The court says, if the witness admits this is unusual, I get to quote you. If the witness admits, we get the impeachment from Mr. Rand, but Mr. Rand is not a witness. Now, if the witness denies, then I have to go to Mr. Rand and ask him, based on his conscience, will you come forward with this instead of asserting the shield in the interest of justice so this witness can't get away with lying? And I know Mr. Rand, I think if that scenario unfolded in this room, he would do the honest and honorable thing. Ms. Abramson says, okay. The court says, Mr. Rand, stand up and take a bow. Ms. Abramson says, see, sometimes it's like what you do with children. You tell them you have high expectations for their behavior and hope that they will conform to your expectations. But I have no secret deal. The court says, I'll keep that in mind next time I hear some praise, whatever little I hear from counsel table, which I haven't heard much lately. Let's go on to the next issue. Mr. Levin says, Your Honor, before we do, may I revisit? Ms. Abramson says, that was before he got mixed up with his lawyer, wasn't it? No, I'm kidding. I had nothing specific in mind, Your Honor. Mr. Levin says, there are a couple issues that as Ms. Abramson was dealing with this other issue I was thinking about. One is this shotgun can be rendered in a manner that it could not possibly work. It could not possibly be a dangerous weapon. It could not be a threat to any deputies or any court personnel, so that if Erik Menendez is required to handle it, it's not as though he's holding a live shotgun. I'm concerned about the security in the courtroom. What's going to happen with the deputies? Are they going to position themselves to leave an additional inference or to give an additional inference to the jury that Erik Menendez holding a shotgun is more dangerous than he is just as he's sitting there testifying? And since there are ways in which a barrel can be plugged by welding it, firing mechanisms can be altered. So that is all it is. So all it is then is it's a demonstrative piece of evidence that the court feels it wouldn't require perhaps the sheriff's department to do anything special, and they could remain in their places and do what they normally do. Court says, well, if you can alter the firing mechanism, the firing pin, in such a way that it won't operate, that's fine. But I think the other portions of the weapon would still have to operate, as far as the ejecting the shells and the mechanism itself that pushes shells into the chamber, that sort of thing. Mr. Levin says, well, what I would suggest is that it's highly unusual. I have never seen it done in any homicide prosecution I've been involved in, with the prosecutors handing a weapon to a defendant. But since it is the sheriff's department that is providing the security and they don't have firearms and ballistics experts, they could have one come down and remove the firing pin so that the deputies here are assured that the weapon cannot and could not be fired. And it could be demonstrated, I think, in such a fashion where the jury doesn't get some inference that Erik Menendez was holding the shotgun. Is, Ms. Abramson says, Deputy Wolf is indicating in his opinion it would still require certain security procedures. Mr. Levin says, if that's the situation, I think before we go forward with a shotgun, the defense wants to know what additional security would be required to do the demonstration, because that's a separate issue. Court says, we'll work it out. Mr. Levin says, well, I'm very concerned, Your Honor. The court says, it'll be worked out. Okay, what else? Ms. Abramson says, it just should be added to the court's 352 analysis that to give the defendant such a weapon is going to make the sheriff's deputies do certain things that are going to give the jury the impression that my client's dangerous, and that should not, and that should go into the mix. In any event, if I'm understanding right, what the procedure would be, or I would ask the court to require that before the prosecution asks for the weapon up or tries to hand it to your client, that we have some notice of what it is that they're proposing. Court says, well, it could be prefaced by some questions before Mr. Khan asks for the weapon to be brought up, some questions of your client. I'm sure it will be, says Ms. Abramson, but before he then calls for him to handle. Mr. Levin cuts her off and says, further, I think he would be required to lay a foundation that which he desires to do can be done by the witness if he is trying to get the witness to demonstrate how, trying to navigate the dog and this at the same time, sometimes hard. If he is trying to get the witness to demonstrate how the weapon operates, perhaps. The court says, let's not get into the details of it, because at this point, your examples might not be anything to do with what he proposes. So I don't want to get into any further. I don't want to get any further along. It doesn't really help us. Okay, what else? Ms. Abramson says, that was our laundry list, Judge. Court says, okay. Then we dealt with it. I'm going to sign that protective order involving Mr. Rand's book or manuscript as a faxed copy that I have. What is the people's current position in regard to a psychiatric or psychological examination of the defendants? Mr. Khan says, well, once again, we have been proposing that the court order that the defendants submit to a psychiatric evaluation, and that's my understanding, at least at this point. I'm sorry for all the bumps. My dog keeps bumping everything. This is very irritating. Well, once again, we have been proposing that the court order that the defendants submit to a psychiatric evaluation, and it's my understanding, at least at this point, that it's only the defendant, Erik Menendez, who's testifying, and that only he is going to be calling an expert on his behalf. Unless there's an indication to the contrary, we'll renew that request at the time only as far as Erik Menendez. Court says, okay. And what is the defense position as far as Erik Menendez? Ms. Abramson says, well, I'm not sure what the people are renewing. The request is already on the table. Court says, all right. Now, the timing of it. Ms. Abramson says, well, we think that it's not ripe until after our expert testifies, if he testifies. The court says, is there some doubt that your expert is going to testify? Ms. Abramson says, you never know till the end. The court says, is there some real concern that you're not going to call him? Ms. Abramson says, I don't know what's going to develop on cross-examination, but right now it is my plan to call him as the court knows. But until he does testify to state of mind and to psychological specifics, I don't believe that people have a right to have my client examined. Court says, well, we're now at a stage where we're going to have a recess of 1 week. And my thought is that that would be an appropriate time to do this. So they're probably going to have like a break, a 1 week break or something for the holidays, it seems, for Christmas and New Year's. So he wants, if they're going to do it, a psychiatric evaluation of Erik, then that's when they could do it. He's proposing. Ms. Erickson says, well, it might be convenient, but I do not believe legally it is appropriate. Moreover, we're still in the position that we are requesting that any such psychological examination as ordered, that the order include the right for counsel for the defendant to be present before our expert, Dr. Vickery, be present and for it to be videotaped. Dr. Vickery testified in the first trial also. And it would simply point out that in the most common area of litigation where there is expert examination by the opposing side, which is in civil litigation, counsel for the examinee is routinely present. Experts for the examinee are routinely present, and we think in a death penalty case, when the expert involved has already gone public dismissing our defense in print as being, quote, novel, when that expert has, we do read a few things here and there. So apparently, the expert, we think in a death penalty case, when the expert involved has already gone public dismissing our defense in print as being novel. So some expert for the state is speaking to publications where it's being printed that he said that the defense's strategy, the defense for the defense, meaning the abuse and years and years and years of abuse and wanting, thinking that they were in danger, all of that is a novel idea. It's a novel defense. They're trivializing it as just some kind of garbage BS. The court says, I was just reacting to the way your voice rises, and Ms. Abramson says it always rises when I get going. Why is the judge even, like, the judge tries to be friendly with them, but he's actually a total jerk to her, so I don't even understand, but whatever. Court says, sort of like pushing a button or something. Ms. Abramson says, it's the wind-up button. I can't stay at that pitch all the time. I'm sure you're happy to hear when it gets going. We think Dr. Dietz is extremely biased. Coming into this bias, he has expressed bias to me on the phone when I talked to him about this case some months ago. We know that he's a hit man for the prosecution in that defense. There's no game about it. They didn't pick him because he's an expert in child abuse. He has no background in it at all. And we know that his opinion is a foregone conclusion, and we'd like to at least try to level the playing field. I'd like to be in a position where my client is, in fact, examined by Dr. Dietz, but I want it under circumstances where we can know precisely what he did and where he is constrained from doing anything inappropriate. And the only way to assure that with someone coming into a case with with as much factual information out there so that he could have pre-formulated beliefs, and in my opinion does, is if such an order were to include the right of counsel and the defense expert to be present and a requirement that the examination be videotaped, which the sheriff's department can arrange. We have explored this, but in any event, we still don't think it's appropriate that it be done until after we have tendered our testimony. And in fact, it doesn't really make any sense for Dr. Dietz to be doing this until our expert has testified, since he would not know what are the areas to explore in claiming support. Where was I? Since he would not know what areas to explore that might support, or that our expert is claiming support his opinion until he hears that opinion. So it kind of doesn't make sense for them to do more testing and stuff until they hear the defense's side. But anyways, that's our current thinking on the Dietz issue. The court says, what is the people's response? Mr. Khan says, yes, at this time, I wouldn't oppose the videotaping of the interview. It's my understanding that Park Dietz was interested in doing that himself. So I'll discuss this further with Park Dietz. But at least at this time, I don't oppose that. I will oppose, however, the argument of counsel that she and the defense expert should be present at the time of the interview. There's no right to have counsel or a defense expert present during that interview. The court says, in McPeters, what was the order? Did the order contemplate counsel being present? Ms. Abramson says, I don't know. I don't have that with me in front of me right now. I didn't know that was coming up today. So honestly, I can't answer that question. Mr. Gessler says, I've read McPeters a couple of times, but not for today. I can't remember if that issue arose in that context, Your Honor. We can, as to whether or not counsel requested to be present or there's a pause in the proceedings. The court says, well, I'm looking at the McPeters case. It doesn't talk about the issues raised by counsel here. It's just a court refusal by the defendant. It seems to me there might be other cases. Although I've raised the issue now, I do it because of the week between Christmas and New Year's when the court is not in session. I haven't reviewed the cases either since we had our earlier hearing, although there had been further litigation in the Ninth Circuit on the subject. Also, approving the government's right to have these examinations prior to trial, as I recall, in the Ninth Circuit case. Mr. Gessler says, was that a review of the state court case or federal court case? The court says it was a federal case. What I'll do is ask that counsel review the cases and the briefs since you weren't aware what I was going to bring up, that I was going to bring up this subject, and state to the court any authority for the proposition, pro or con, to the proposition that defense counsel has a right to be present for the examination. I believe there is case law on that. As far as the timing on it, I think we're getting close enough to the point where such an order can be made since the defendant has already testified as to a mental state. Ms. Abramson says, but he hasn't testified to any mental condition. All he talked about was fear, and I don't think they have a right to a psychiatric examination of the defendant who testifies to fear. The only thing that gives them the right to the examination is the defendant proffering expert testimony, and that hasn't even happened yet. Court says, right. Well, as I said, we're going to the point now where the issue is ripe. So what I'll do is deal with the specifics of your objections or your, Ms. Abramson says, we've still never been given a specific. We have nothing in writing from Dr. Dietz. We have no idea what materials he's been furnished with. We have no report, preliminary or otherwise. The court says, go ahead. And we have never been told what exactly he's supposed to be evaluating the defendant for. So I don't think the people have yet complied with what I think are the minimal needs of discovery here so that I can make the informed decision to whether to advise my client to cooperate with such an experiment or not. The court says, as I've said, I'll give you time to review your briefs since, again, that basically gets to an issue of the defense having a veto power on the subject just by saying, don't like the way the doctor says something in one of his responses to my inquiry, or I just don't feel quite right about it. So it's really my decision and not my client's decision, and it's a right of counsel issue, and therefore can't be commented on. I can see those things happening, and I don't think that they are going to be obstacles to the court making an order that you feel that you need more information on, and what exactly he's going to ask and how he's going to ask it. I don't think those are proper subjects for the court in making its ruling. That you have these issues that you want to identify first, I don't think that would foreclose the court making an order. Ms. Abramson says, I don't think ordinarily it would, but in the circumstances of this case, Your Honor, where there's been extreme controversy, an enormous amount of publicity about the defense in this case, and some of the issues that were raised, Dr. Dietz is a person of tremendous controversy who has his own assertion with a tremendous amount of publicity. He has no experience in this area, but he is the people's choice. He is the people's choice because he's usually the prosecution's choice in high-profile cases, and I think it's very obvious why they've chosen him. So Dr. Dietz always testifies well for the prosecution. And we should at least, I'm not saying that it's the court has to provide me with this information before it can make an order, but I'm just trying to be candid with the court that unless we have some idea of where Dr. Dietz thinks he's going and some right to be present to make sure that he goes in legitimate ways, I'll advise my client not to cooperate. And I don't really want to have to do that. I'd much rather that he be evaluated and then Dr. Dietz can tell us what he already knows. But I'd at least like to show that he made him available and be able to make or to have useful information about the methodology used in any body language that Dr. Dietz displayed and any other thing that cannot merely be captured on videotape with which to impeach the opinion that he is invariably going to come up with. So, that's what I'm trying to put in the mix here. I realize the court doesn't need my agreement to have the evaluation before the court can order it, but I think under the circumstances of the case that the people perhaps should have to comply with these requests. The court says, okay, I don't, quite frankly, think those are going to be persuasive. Otherwise, as I said, the defense would have a veto, and that's not the issue. The issue is not if the people have a right, it's a question of when they can do it. And it's up to them to have their selection of the witness. And before the witness testifies, you have a full right to discovery. That discovery doesn't relate to selection of the expert or the court making an order. I'm just concerned. We've lost a lot of time in this trial due to illness of various participants, and we're still a good distance away from completing the trial. And an examination takes time, and we do have time between Christmas and New Year's. So I would like to, if it's legally appropriate to do so, to make the order before we take the recess for the break. I'll give you a chance to review your materials and come back early next week and we can resolve it. All right. Anything else now that you want to talk about? Mr. Khan says there is an issue about the amount of loss in the 2 burglaries. The court says, well, perhaps you 2 folks can work it out. The defense disputes the amount. I think you can come up with a range that wouldn't be in controversy here. I don't think it's such a big issue. Ms. Abramson says, I think the whole issue of the number is in controversy. My client testified to what was taken. He indicated that it was substantial, that he knew it was substantial. I don't understand why the people need to prove a dollar amount when I can't. What are we going to do? Guess that these people inflated 50% versus 100%. I don't understand why it's relevant. At this point, they've got what they needed. This isn't a childish prank which is what the court indicated would have been a valid concern. He went through the whole laundry list of what was taken. I don't see why the numbers matter. The court says, well, we did have reference to a certain dollar amount, did we not, in regard to the cash? Mr. Khan says, all we had is $1,000. We're talking about in the list burglary alone, we're talking about $102,000. And so far, and so what we have is 1,000 worth of cash and some jewelry in a substantial amount. Well, substantial is relevant. What does that mean? $500 worth of jewelry or $1,000 worth? The jury may be thinking it was a $2,000 burglary when it was $100,000. Mr. Khan says, or I'm sorry, Ms. Abramson says, well, Mr. Khan says, I would oppose that if no agreement can be reached concerning that in our rebuttal case, we simply be permitted to call someone from the List family and from the Ginsburg family. Ms. Abramson says the whole point of this is that it's coming in under the notion that this is relevant to explain the relationship between Erik Menendez and his parents. So it doesn't make any difference what the amount or value of these people's jewelry was, since they got it all back anyways. And there's no way to prove that the value is, there's no way to prove what the value is. What are we going to do? Have a contest over the jewelry? It seems to me that is a useless pursuit. If counsel wants to look in the burglary reports, they'll see that $1,000 is accurate as to what kind of cash was in the safe as to the List home. And as far as the value of the jewelry is concerned, there's no way to litigate that now, but I don't see why it matters. My client said substantial. He testified to specific to specific items taken from the Ginsburg home: silverware, china, plates, solo. All of those things, which I think impresses the jury that it was a substantial burglary. The fact of the matter is, the list burglary was started out as something of a prank. The fact of the matter is, the list burglary was started out as something of a prank and therefore was not as intensive in the type of things taken. But beyond that, remember, all of this is supposed to be admitted because it means that my client did something bad and there was conflict with his family. The amount shouldn't make a difference on that. Mr. Gessler says, I join in that on behalf of Lyle Menendez, Your Honor, as to the burglary admitted as to him, and for the same purpose, that it was to show the relationship between him and his parents. And Jose was all upset with them because of the burglaries, and that's why he decided to kick him out of the will. That's why it's relevant, not the amount, not the dollar amount. The essence of that is shown in the Dr. Oziel tape of December 11th in the 2 comments made about that particular Calabasas incident, as it is called, and the reaction that their father and mother had concerning it. It really makes no difference what the amount of money was taken. We know the reaction of the parents, and that was the limited value the evidence was given coming in. So it would seem that the amount of the burglary is simply non-relevant to the relationship between the young men and their parents, and if it has any relevance at all, it would seem to be substantially outweighed by its prejudicial value here. The prejudice outweighs the probative value, the prejudice being just how much money they took, which doesn't really add to the relationship between them and their parents. Ms. Abramson says, I think frankly, the way to cut through all this, the more significant number, if there is a significant number, is the amount of restitution, not the amount of, the court says, well, I was going to ask if someone knows how much restitution. That's not the significant issue, but is an issue since the father had to pay that back. Anyone know how much the restitution was? Ms. Abramson says, we do. Court says, how much? I'll be willing to share if the people would trade that number for these other numbers and stop this argument. According to my client, it was about $12,000, according to Lyle Menendez's understanding. The court says, anyways, let's hear the people's response. Ms. Abramson says, I think I can find an actual number in a file Mr. Chalif turned over to me. He handed the negotiation. The court says, okay. Mr. Khan says, I think that counsel's overlooking the real issue here. The real issue here is supposed to be the manner in which this may have affected the relationship, and the matter depends upon the nature of the allegation and what was the apparent loss. Counsel is arguing that the ultimate issue is the true value of the jewelry. That's really not the ultimate issue. The ultimate issue here is that there was an allegation against the defendant that the defendant had been involved in a burglary, which, as far as the list case is concerned, involving the loss of in excess of $100,000. That is the fact, and that is what Jose Menendez apparently knew, that it was that is what is indicated in the police report, and that is what would have affected the relationship, the belief, and the understanding that the defendant was involved in a burglary in which the loss was in excess of $100,000. So whether that was an inflated amount or not, that would always be argued. Where did they put all the stuff when they stole it? Like, the parents didn't notice them bringing in like this Soloflex machine or whatever it was, like a workout equipment. There's nothing to preclude counsel from arguing that that was an inflated value, and perhaps an astute businessman such as Jose Menendez would have known that it was an inflated value. All of those are valid arguments that can be made. The bottom line is that this is what was apparent. This is the nature of the allegation, and that is what affected the state of mind. So I think that value should come in whether or not it was inflated, and counsel can argue to the contrary. We're not arguing it for the truth. We're not arguing that the actual loss in the case was $100,000, and perhaps it can even come in with a limiting instruction to that effect. that it is not being offered to show that the true loss was $100,000, only that that was the allegation in this case, an allegation to which the defendants ultimately pled guilty. Ms. Abramson says, well, first of all, is so rife with speculation. It shows why, frankly, Your Honor, in spite of the court's rulings, I'm not trying to be contrary today. I still don't understand how this evidence is supposed to somehow tell us what people were thinking, whether it's Mr. and Mrs. Menendez, or for that matter, our clients at the time. And here is the prosecution's offering a purely speculative argument that it made a difference to Mr. Menendez, that the allegation was $100,000 rather than $60,000 or $50,000 or whatever else it could have been. And the people have absolutely no evidence whatsoever to show how Mr. Menendez reacted to this, other than information that came from the defendants to begin with, because the family never told anyone about this. This was part of their secrecy and their privacy. They don't have any evidence that it mattered to Mr. Menendez that it was $100,000 or $200,000 or $1 million. And yet we're supposed to draw speculative inferences that because it was more money, what? He was madder with his sons, or he disapproved of them more, or he thought they were even stupider, or not having gotten away with it, or what? It's purely speculative. That's why the actual amount doesn't mean anything. Now, if an amount might have meaning, it might be the amount that he had to fork over. It seems to me that might be. It's speculative, but that might be more probative value, what he had to actually pay out of pocket. So there was restitution. The families, if there was, something not necessarily returned or whatever, there was money exchange from Jose to the List family and the Ginsburg families, to reconcile for what Erik took. And the other reason that this supposedly is relevant, the burglary evidence, is because it's what led them to go see Dr. Oziel, and that doesn't depend on a dollar amount either. But we're off in speculation land. They don't have any witnesses to say. They don't even know how the burglary information unfolded. They don't know that Mr. Menendez even knew that what those numbers were. They don't know whether he had copies of the police report, and there's no reason to believe that he did. He hired a lawyer. The lawyer had the police reports. The lawyer may have gone over what these amounts were, and it's the lawyer who would have told Mr. Menendez. And I know, as an offer of proof, that the lawyer was in contact with the sheriff's department and the victims of the burglaries to figure out what the actual loss was, and it's the lawyer who negotiated returning what my clients already testified was a U-Haul truck worth of merchandise to the Malibu station, so the victims could get it. So it's just the wildest speculation to assume that Mr. Menendez even knew the specific allegation. And when my client agreed to $654 probation in juvenile court, he was not responding to a petition that laid out the dollar amount as most burglary petitions do. So he can't say that my client admitted that that was the amount that was taken, because he didn't. Mr. Gessler says, further, on behalf of Lyle Menendez, Your Honor, defendants did not plead guilty to something. He has not admitted the amount of loss on anything that he took part in. And again, I agree with Ms. Abramson. If there's any probative value to an amount here, it would be the out-of-pocket loss to Mr. Menendez as to how mad he would get. I mean, he might be madder if you pay out $12,000 than if you pay out $1,000, but you might be hopping mad if you pay $100,000. But the real things that make you mad is how deep you have to dig. That might have some probative value. I don't see that anything else does, and it would be, again, outweighed by the prejudice. The court says, all right, we had similar discussions, perhaps not as protracted yesterday, on the same subject. The amount will never really be determined. I guess with the prosecution that there is a reported amount, and perhaps that amount was communicated to Mr. Menendez, but we really don't know that. As to the amount that was in the police report, all we know is that's what was in the police report, the amount of value that the victims placed on their loss. What I would suggest is, if the defense has some way of verifying the amount of restitution, such as a file that has some documentation reflecting the amount of restitution made by Mr. Menendez, that be produced, so that at the very least, that amount can be brought before the jury and it would be clear, whatever that amount is, that there was a substantial loss above that which was dealt with return of property, and the property has been identified, whatever the property is. Ms. Abramson says, well, there's another way, of course. I mean, I'll look back at Mr. Chalif's. What I have is obviously a privilege file, but I'm willing to go into it to resolve this issue. I'll look back through Mr. Chalif's file. He may actually have a copy of the checks in there, and he may, if not, I think he might have made the payment from his trust account. He may have those records. The other way, of course, to find out is for the prosecution to call them up and ask them. Court says, obviously. Ms. Amerson says, since they got the money. The court says, obviously. Ms. Amerson says, but I'll look through the file to see if I have the documentation there or if Mr. Chalif can provide me with it by Monday, and then we'll at least have that number. Court says, all right. I would like to get that issue resolved. It consumed much too much time for the very little value it has. So other than hearing what the amount is, I don't anticipate having much more conversation on the subject. Anything else now? Any issues? All right. So on Monday, the prosecution is going to file your position on, or any case, authority dealing with questioning of the defendants about statements he made to Signorelli and Oziel without your ultimately calling Signorelli or Oziel. The defense indicated it will file a brief on Monday dealing with the proposal of Erik Menendez to present the testimony of Lyle Menendez from the first trial and authority for that proposition. Something that the defense brought up this morning is a possible event. And the court indicated that it would expect the prosecution to be prepared with a response authority dealing with the general subject and the specifics of both the admissibility of this evidence and the nature of its presentation if it's admissible. There was some discussion about the defense wanting to limit the testimony of Lyle Menendez, not offering all of it, only portions that don't relate to or excluding matters that relate to Dr. Oziel, that relate to Oziel's testimony that has not been presented to this jury, and whether or not such can properly occur, editing out portions of the testimony from the first proceeding. So those things should be presented to the court on Monday. So I guess the defense wants to admit Lyle's testimony, but leave out all the Oziel stuff if possible. Ms. Abramson says, also, Your Honor, the impeachment issues, whether if we were to offer his testimony in whole or in part, the allowable scope of impeachment, which the court says, well, you were going to brief that. Ms. Abramson says, we are going to brief that, but the people may want to be prepared to make their arguments. Court says, we had some discussion about that scope of 1202 of the evidence code, impeachment of the declarant who does not testify before the jury and has testified in former proceedings. Okay, anything else? Mr. Levin says, is the court going to allow defense counsel to see the shotgun? Yes, says the court. Ms. Nahara says, Your Honor, question as to the brief concerning Lyle Menendez's taped testimony. Our understanding is that the defense will be filing one on Monday. Is the court expecting us to have a response also filed by Monday? No, I think you're entitled to see what they have, but you can anticipate and do your own independent research on the subject and be ready to get one in short term. You don't have to wait a week. Ms. Nahara says, I'm saying we won't have one ready on Monday. Court says, no, I don't expect you to have one until they file theirs. So usually one side files, the other side gets to look at it and respond to that filing. So he's giving her a chance to respond, and she can't file hers until after she gets the defense's filing. But I think you could certainly do your research, get your research done, and get ready to get it quickly. All right, we'll be in recess until Monday at 8:30. They adjourned at 2:35 in the afternoon. Look at that. They started at 8:30 in the morning, ended at 2:35. We read it in under 2.5 hours, really. So yay, we did, we got through all those arguments. I wanted to get that in one recording so that next episode we're just going to get straight into Erik's testimony, hopefully. I should double check and make sure that that is the case because I don't want more arguments. But anyways, I'm sure he'll be back on the stand. So it actually looks like we're not going straight into Erik's testimony. I'm glad I looked because we have someone named Joshua Crom who is going to be testifying up first. So Joshua Crom was a witness. Let's see who he is first. Mm, he was residing. Oh, so he's a neighbor. He lived near them. That's what this is. Joshua Crom, they probably had scheduling issues. So Erik is still sworn in and on the stand, but they had to break from him and go to this other witness, Joshua, um, because probably timing of the witness. So that's who's next. And hopefully we get to Erik then still in that episode. I'll have to double check. I think so. I don't think Joshua's on very long. But that's where I leave you guys for today. Let me know what you think in the comments below about those arguments, about the judge's rulings. He pretty much seems to side with the prosecution, in my opinion. When he doesn't really have a choice and it is clear that the defense has won an argument, then he gives it to the defense. But in most cases, he tries to see the state's side or defend the state, it seems to me, my opinion. What do you guys think of Judge Stanley Weisberg? We saw him in the first trial when we streamed it, and this is him still, the same judge, and the way he talks to Ms. Abramson, so relaxed and so nonchalant, like they're friends, but he's so rude to her and his rulings. It's just really bizarre. I feel like there's some misogyny going on there a little bit. Just saying. And I don't know uh, Stanley Stanley Weisberg's whereabouts. There was an episode where after we streamed the trial, I went and I did like a where are they now, and I could not find him. So there's no like real specifics on where Judge Weisberg is now, or if he's deceased, if he's still alive. I have no idea, but I think he was biased in this case. That's what I know about Judge Weisberg for sure. Anyways, let me know in the comments below what you think, and I will see you guys in the next one. Take care. Bye. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.